I think the danger is that we could see our big firms either choosing to go and be regulated in England and Wales, which is an option that they have because of the cross-border provisions that we now have. If you have an office in London, as almost all of our big firms have, you can have the tail wagging the dog. You can choose to be regulated in England and Wales if that allows you a more liberal business structure. And the other danger is if English firms are allowed external capital, they will be capitalised to the extent that you could start simply taking over even some of our biggest firms and treating them as, if you like, subsidiaries.
Well, very briefly, because we've got a lot to get through.
I mean, if there's any way of, if you like, cutting off the top level in a way to allow all of that without, if you like, interfering with the way in which things are operated for the more traditional, the one-third at the bottom.
The key point is, and it's a very, very important part of this bill, that none of this is in any sense compulsory. It's entirely voluntary. The traditional, it actually says specifically at some point, the traditional form of legal practice in partnership with other solicitors or sole partnership is not to be affected at all by that. And we think, this whole regulatory area is a difficult area, but we think that the government have achieved a compromise that allows everybody to get what they want from the market and yet preserves the importance of a unified legal profession, which we might get a chance to say something a bit more about later on.
I think we've had a fairly lengthy kick at that particular ball, and we're now moving on to other issues. Members will note that in his answers, Mr Smart and his colleagues have in fact answered a number of the questions which we were anticipating asking, and members will no doubt dovetail their questioning accordingly. Can we turn to the independence of the legal profession, however, and I'll go to James Kelly.
Thank you, Convener. In a previous answer, Mr Smart, you made reference to the importance of protecting the independence of the legal profession in Scotland. How do you think the proposed powers in the bills ascribed to Scottish ministers in relation to regulation protect the independence of the legal profession?
Although it's asked to me, if you don't mind, I'll get Lorna to answer that.
Yeah, sure.
I think we've already made our evidence known on this, that we see a need for the Lord President's role to be re-established beyond just simply a consultee but approval mechanism. So we do think the bill needs amendment in that respect, and we've made that point. We also have seen the evidence of others talking about the role of the need for perhaps a super regulator in that sense, as they've got in England and Wales, and feel that that's something that's inappropriate for the Scottish market being the size it is. We don't think that there will be a requirement, given the bill's provisions, for ministers with independent advice to decide. And I think if you supplement that with the Lord President's role in approving regulators, then again you re-establish or ensure that the independence of the legal profession is protected. We would have concerns about an additional layer, an additional quango, and the cost of that to consumers of legal service in Scotland, and indeed to potentially taxpayers in that respect. So very much the basis of our argument about ensuring the independence of the legal profession is that the Lord President takes a role in approving, alongside ministers, those who get to regulate people who deliver legal service. I don't know if Michael wants to add to that in terms of the bill.
Yes, if I can supplement Lorna's comprehensive answer. In the bill, of course, there are provisions in respect of the regulatory objectives where approved regulators and indeed by virtue of Section 86, the existing regulators such as the Council of the Law Society, the Faculty of Advocates, and just wait for the noises off to stop. Clearly, someone
Make inquiries into what's going on here. Before we resume, can I say that we are attempting to do something about this. Unfortunately, the culprit is on the roof, and whilst we have contacted facilities management, do you find it totally distracting, Mr Clancy?
Very little distracts me, Convener, but I'm sure that the sound engineers will be able to filter out any of the awkward noises. That might mean that the official report simply records your man on the roof. But anyway, as I was saying...
Just hold on. You're quite comfortable that we resume? I'm
quite comfortable.
Right. Committee,
if you're comfortable, I'm comfortable, Convener.
Reconvene. Mr Clancy.
Thank you, Convener. The bill has in the regulatory objectives provisions to promote the independence of the legal profession, and I think that applies not only to approved regulators but also to the existing regulators under Section 86. Furthermore, Scottish ministers who have a particular role in relation to the approval of regulators are also captured by the regulatory objectives in terms of Section 4, ministerial oversight. The trouble is, of course, that that's only so far as practicable, and I think that particular provision needs to be strengthened a bit. Lorna adverted to the role of the Lord President, and we certainly think that the role of the Lord President should be enhanced from his position in the bill. In the original consultation, Wider Choice, Better Protection, the Lord President was listed as being someone who had to agree to the approval of an approved regulator and to their decommissioning, and yet in the bill he turns out as a consultee in that process, and I think that it would be appropriate for the Lord President to be reinstated to his position as someone who acts in concert with Scottish ministers in that respect. When it gets on to the role of Scottish ministers specifically regarding elements in the legal profession, there are concerns about how that works. I had referred in discussion with Mr Brown earlier to the head of legal services in section 39, and the head of legal services has to be a solicitor. But under section 39(9), Scottish ministers can make regulations about that person's functions. And I think that it is inappropriate that Scottish ministers should be able to tell a solicitor what to do. Furthermore, in terms of section 35, the step-in powers by ministers, we see the proposition that ministers can create an approved body which would then be involved in the delivery of or the licensing of those delivering legal services. And I think that that is also a difficult issue because as Scottish ministers under section 35 could create an approved body, they would then have to approve that body. And we see a kind of infinity loop of ministerial control, and I think that that too is something which should be struck from the bill. I think I've covered all the parts, but you have a point to add, Katie.
Just a small point that in his response to the consultation, the Lord President himself thought that his office should have a role in the authorisation of regulators of alternative business structures, and he made the point that the risks posed to the due administration of justice by inadequate regulation are sufficient to merit that level of involvement on the part of the holder of that office.
That handles these particular issues coming out. Sorry.
Just one final point, Convener. Just in terms of the costs of the regulation that would come into force if the bill was passed, do you think the costs are adequate as they're outlined in the bill currently?
I think that's a difficult question to answer at this point in time when you look at an unknown picture in terms of the number of licensed legal service providers that will step forward, the number of regulators that might step forward. There's clearly provision in the bill to open up that to regulators beyond the Law Society, and I think we've made that clear in our evidence back on the financial memorandum. But I would draw back that issue. One of the things that will ensure that this is more cost effective than what you've seen south of the border is trying to avoid superstructures around this or super regulators. The Legal Services Board and the Complaints Commission in England and Wales is currently costing around £39 million.